Please note that this presentation is an educational service offered by Alcorn Immigration Law. All information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. So I'll be happy to answer your questions today. That is primarily the point of this webinar. You can put them in the Q&A panel. We are being recorded today. This will be shared with registrants, and wherever you see the QR code, that is where you can sign up for a consultation with us. And I will also put the link to our intake questionnaire into the webinar chat so that you can also click on that as well if you would like to book a consultation with me or my team. Okay, well, at Alcorn, our mission is to overcome borders, expand opportunity, and connect the world by practicing compassionate, creative, and cutting-edge immigration law in service of the betterment of humanity. And my name is Sophie Alcorn. I'm the founder of Alcorn Law, the host of the Sophie Alcorn podcast. For 4 years, I wrote a column on at TechCrunch called Ask Sophie. I meditate, and I think that the world should be a place where each person has the opportunity to live in peace and security and grow up and become self-actualized and work in their flow state and contribute something back to the world to make it a better place for everybody. So what I'm trying to do with immigration is by focusing on founders and early stage technology startups, help in a very impactful way to empower people who are trying to make the world a better place. So I'm just going to provide a brief immigration overview before we dive into the questions, and we have up to an hour together. I'll be focusing on the Q&A panel, not the chat window. So if you have a question, you can definitely put it in the Q&A panel, even if you already put it in the chat window. And please note that you can also use the anonymous attendee function in the Q&A panel if you would like to keep your name anonymous. So there's been lots going on in immigration recently. It's always a busy time. There's been a lot of legal changes, political changes, economic changes. So it's definitely a constantly changing landscape. So it's different than the last time I had a webinar. That always happens, but we do try to update our community with our newsletters, which you're welcome to subscribe to, and our Motivational Mondays and other blogs and writing pieces that we do, podcast, and these webinars, which we try to do monthly. So what we are continuing to see is increased security that has been really on the rise all of this year. Also, continuous vetting. In the prior administration, it was called extreme vetting. It's thorough vetting for sure. That's continuing on right now. And we're seeing that for applications, for petitions, officers with State Department, Customs and Border Protection, and USCIS all conducting enhanced screening of applications and petitions, certainly. In the market, there continue to be layoffs affecting individuals in the technology sector and other sectors. And one of the things that we've been doing that got paused a little bit in September because of the $100,000 fee, which turns out does not apply for transfers, fortunately. But we continue to help aspiring founders transfer their H-1B to their own startup with the rapid potential for scaling, or to their own business that they're recently forming as an entrepreneur for consulting or other types of professional services or other types of companies. So we can certainly talk about options for that in the Q&A if you're interested. Recently, and we had a newsletter go out about this, we did see the end of automatic work permit extensions. There are some exceptions, which are those mandated by law or regulation. So this was a policy change, but not a legal change. So it affected some, but not all categories. Additionally, the government shutdown is over. We did see that prior to the government shutdown ending, the Department of Labor was able to resume processing of the labor condition applications, which are LCAs for the H-1B process, and the prevailing wage determinations and PERMs for the green card process. So it sets a very interesting precedent if there is a future shutdown. The number of shutdowns, you probably saw this news, but there are shutdowns kind of frequently now, and this was definitely on the longer side. But it was very interesting because it's the first time where Department of Labor processing for immigration was permitted to continue, even though the government shutdown is in effect. USCIS and the State Department are funded by filing fees for immigration, but there are no filing fees to the Labor Department for immigration. So usually they shut down, but an exception was made, so they got to stay open. And if somebody, hopefully, if you had like the end of an H-1B grace period happening and you needed to file an H-1B transfer, there were mechanisms made available for emergency requests if you were not able to get an LCA filed in time. So hopefully everybody made it through that okay. We're also starting to look at preparing for H-1B season. If you are a company that would like to sponsor somebody, including yourself, we are accepting clients for the March 2026 H-1B lottery, which is called the fiscal year 2027 CAP registration process. We're accepting clients. Our prices go up in January. But if you have a company and you know who you want to sponsor and you would like our support, that process will be changing. It is more enhanced in terms of the amount of information that we have to provide regarding the person, the company, and the role prior to the registration process. So that'll be a little bit of a new system. And we're waiting to see if the prevailing wages will change and if there will be a weighted system. But the lottery will continue and we are accepting clients. Additionally, I would encourage employers to review their extraordinary ability pathways for employees. These could be things like O-1 visas for extraordinary ability. Individuals could also obtain these through an agent to have a variety of jobs and streams of income, which is possible. And there are still lots of interesting ways to do immigration, and we're getting them approved for people continuously. So if you need help, you're welcome to reach out. Now, I do recommend continue to stay informed and be proactive. Thank you for being here with me today. I spoke with some of you this week and you said that you would be attending, so appreciate you being here with me. And as I have been looking through the attendee list, I see a lot of names who I know already, so thank you. And if I don't know you yet, thank you for being here, and I look forward to meeting you. Now, additionally, we're available to work with you or your company if helpful. There are a variety of USCIS, Department of Labor, and other types of news updates happening all the time. We're in our newsletter continually synthesizing the key takeaways for people looking at business immigration, especially in the startup world. So there can be a lot of streams of information to synthesize, but for our core clientele of people in tech, aspiring founders, scaling startups. We're doing our best to continuously give you the updates that you need. We do offer a variety of immigration solutions, visas, green cards. My online class is complimentary. It's called Alcorn Academy, and it is 15 videos on how to become more qualified for an O1A, EB1A, or EB2 NIW. So you're welcome to take that. We also have a assessment evaluation program called Legal Launch. And normally that is $3,800 that gets credited to your future O1A, EB1A, or EB2 NIW within 6 months. But we are running an experiment where if you mention that you're on today's webinar and you heard me say that I would offer it to you as a complimentary service, we would honor that. And basically, it's 4 meetings with our team. We give you our 20-page extensive checklist. You upload all the evidence you have already. We do a gap analysis to let you know how close you are to actually filing your case. And if you're not qualified yet, we give you written recommendations for how to become more qualified. And if you are qualified, we can move on to actually initiating your O1A, EB1A, or EB2 NIW. And I put the Legal Launch link. And I would encourage you to please put your questions in the Q&A panel. Even though I'm sending links to everybody in the chat window, I'm going to be looking at the Q&A panel to manage the questions for the AMA portion of today's webinar. The other services we offer before we get into the questions, we do offer O1 visas and changes of status petitioned for by an agent. As I mentioned, the itinerary of services allows you to enjoy multiple jobs and streams of income. The agent we use, who we're not affiliated with and we do not receive any referral fees from, but our clients have had success with in the past, they charge $1,000 to be the agent for up to 3-year petition. We do offer H-1B transfers for founders. We offer a startup consulting package for $3,000. Where we'll help you ensure that your company is set up properly to meet the immigration compliance requirements of the H-1B. We're continuing to offer select EB2 NIWs, mostly for founders and researchers, but sometimes other people. And then we're continuing to support people and win on EB1A green cards for extraordinary ability. And we do other visas as well. If you do reach out and you would like to book a consultation, we'll ask you to complete a form that I put at the very beginning of the webinar chat to our questionnaire. And once you complete those details, then my team will take a look and we'll be happy to see if we can arrange a time for us to chat about your situation and answer your questions personally. Some of those are charged at $300, so just please keep that in mind. Okay, so we're going to go into the Q&A. I did also just want to mention I wrote a book. It's called Ask Sophie, The Founder's Guide to Visas and Green Cards. It's available via paperback on Amazon, Kindle, and also Audible, where I was the narrator. So you can definitely check that out. And of course, you can reach us at hello@alcorn.law, on our website at alcorn.law, and via phone 855-546-0015. Okay. Now with that, I am going to go ahead and start reviewing the Q&A, and we're going to get to your questions because that is the main point of today. So thank you for the applause emoji. Okay, we're going to take the first question right now. This is about the H-4 EAD. What is the best possible way to get the H-4 EAD before its expiration date so that there will be no discontinuity of employment? Excellent question. So the timing is very touchy, and there's been a lot of news on the H-4 EAD recently. I believe it is one of the categories where the automatic EAD extensions is ending that we sent out the newsletter about. But also interestingly, a month ago, the Supreme Court declined to hear a challenge to H-4 work authorization. So for a particular person who is looking at not having any discontinuity of employment, that is a challenge, frankly. There is a way. So I would say the best way for the H-4 holder to receive their EAD as quickly as possible is if the H-1B spouse is filing an extension or an amendment or something like that with premium processing. And if everything can be bundled together on the employer's side, sending it all together at the same time, that may give the H-4 EAD preferential treatment and being adjudicated more quickly. Without that, the only other thing to look at is an expedite request with USCIS. The standards for that are quite strict, but it is possible. But then you can kind of like be pigeonholed into a situation. So where, for example, like if you're requesting an urgent EAD for an adjustment of status, but you have to have the proof that you're financially viable, it wouldn't be positive for H-1B if you were arguing that you had extreme financial harm circumstances to justify the expedite. But there is a website with the USCIS expedite request criteria. I'm going to put that in the chat window for everybody. And that is where you can read about them. The main categories are severe financial loss to a company or person, emergencies, nonprofits furthering the cultural and social interests of the United States, and government interests or clear USCIS error. The best thing would be if your wife's or your H-4 spouse's current employer is able to prepare a letter stating and explaining how if there's a gap before the H-4 EAD comes, that the company will face severe financial loss. And if you go onto that webpage and you scroll down to the accordion section, it explains that a company can demonstrate that it would suffer a severe financial loss if it is at risk of failing, losing a critical contract, or required to lay off other employees. So that would be a place to focus on. Thank you for the question. Will clubbing H-4, H-4 EAD, and H-1B with premium processing guarantee a decision within 15 days for the couple since the settlement agreement and Edekuni v. Mayorkas expired on January 18th, 2025? No, there is no guarantee that filing it along with a premium processing H-1B will guarantee a decision. Many are taking much longer than that. What is my opinion about the recommendation letters for the EB-1A application? Are these a must or a good to have? We do them as a must. We include 4 to 6 letters of recommendation with an EB-1A petition. I have chosen that policy based on doing hundreds of cases over the last 20 years. And I believe it's best because those cases win. For example, I spoke with somebody yesterday who did an O1 with another law firm that has a different philosophy where they try to minimize letters of recommendation. And that person's O1, which is also for extraordinary ability, got a kitchen sink RFE. Now, it's all anecdotal data points. I feel more comfortable knowing that we've covered all of our bases and that I can make the strongest legal arguments possible if I have lots of like glue connecting the dots on the evidence pieces and being able to explain why. Because you can like list an evidence table of contents that says all the things the person did, but unless you bring it back to the legal basis for the EB-1A and why the person is legally eligible, which requires like glue statements, or I just made up that word, but you need to be able to tie it all together. So I use the letters of recommendation as a tool to make sure I have enough glue to stitch together all of the evidence in my legal arguments. Okay. Is the H-1B to B2 to H-1B change of status pathway still viable with the current USCIS guidelines? Have there been recent cases approved that we're aware of? If so, does the $100,000 fee apply? Thank you. The pathway is still viable. We have had recent cases approved who are doing that, and the $100,000 fee does not apply. So if you're on H-1B, you're getting laid off, you need more time than 60 days to find a new job or start your company, it's very wise to do a change of status to B2 as a backup. And then you can always do another change of status back to H-1B in the future. And let's say you're even going to go to another country for a few months and figure out your job search from there. And you were to get your H-1B from abroad because you've already been through the lottery and you had an H-1B before September 9th. I don't remember. The announcement, I think, was on the 19th. The deadline, I think, was on the 21st. I'd have to check. But when that $100,000 fee came into effect, anybody who had an H-1B before that would not be subject to the fee. Okay. What are the latest L1 trends at USCIS and the consulates? There's some scrutiny. We do a lot of new office L1s for startups, and we can usually get the initial 1-year new office L1 petition approved. But then when it comes to the first 2-year extension with USCIS, we've seen scrutiny, RFEs. We're kind of looking at that for a few different clients right now of whether for their after the first year, if they ought to request a normal 2-year extension, which is held to a really high standard of scrutiny. And in some cases, the business has not yet met all the milestones of the business plan that we originally set forth. So the alternative is we can request a second new office 1-year L1 petition as a backup. What's the best path for attaining permanent residence? Is it EB3 or EB5 or EB1 or Golden Visa? I'm on the H-1B with the approved I-140 and a priority date of September 22nd, 2022. Okay. I don't know. It is complicated. I can tell you the factors that I think about when I'm helping somebody personally analyze this, because it's really different for each person based on their requirements, their accomplishments. But I can tell you like the pros and cons of each of these options to the extent that I know them, because I don't practice EB5 law, for example. So, and this person has a 2022 priority date and they're on an H-1B. And I'm just going to assume for the sake of this conversation that they're probably from India. So EB3, if you were born in India or China, is going to take forever. So there's really no point in starting another EB3 perm process, even if you change jobs, because it's probably going to be decades. Sorry about that. And you already have a priority date, so you have a spot in line. So, you know, the clock is ticking for you on the visa bulletin already. So there's really no point in doing an additional EB3. You know, maybe if you had like a, whatever the cutoff is right now, like 2014 or something, like maybe if you had a priority date from back then and you would just switch jobs, then you would really want the new employer to do a perm in the EB3 category for you. But from India, which we're assuming with a 2022 priority date, there's not really a point in the employer doing a perm for you right now. Now EB5, if I believe they changed the rules so that if your priority date is current for EB5, you're allowed to file the adjustment of status. Now, you'll have to talk to an EB5 attorney about that because I'm really not sure of the details. But what I can tell you is that let's say you had an EB-5 pending and you had an I-485 pending and you had an EAD from that adjustment of status process, I would probably still advise you to maintain your H-1B and not activate your I-485 EAD, so that in case there are any issues with your I-485, you are still maintaining valid status as the most prudent course of action. Many people, for whatever reason, have great reasons to like abandon their H-1B and just use the EAD from the adjustment of status, and that's fine. Like maybe you want to have multiple jobs or be self-employed and you can just do it. Like that's fine. I get it. But like if you're good with your current H-1B job, it's just simpler and safer to keep it going if that's your only consideration. Now, EB-1 is a very high bar, very volatile adjudication process right now. Many RFEs and notices of intent to deny for even the highest qualified candidates with excellent EB-1 petitions. As I mentioned, we are still getting approvals, but the amount of RFEs and NOIDs, which is a request for evidence or a notice of intent to deny, has really skyrocketed. First, it was for the EB2 NIW category, and now it's for the EB1A. Now, the gold card is not in effect yet, and it remains unclear to me how and when it would be launched through a legal application/petition process. The most recent announcements about it were in September at the same time as the H-1B $100,000 fee announcement. But as far as I have seen, there is not yet any mechanism to actually apply for a gold card. The latest suggestion is that if a person pays $1 million that they earned, that they would be deemed extraordinary, akin to an EB-1A. And if the person has another person vouching for them who's putting in $2 million to say they're extraordinary, then that would also be sufficient. And the latest proposal in I don't know if it was a proclamation or an executive order, but it's on the White House website from late September. It suggested that this $1 million or $2 million payment would be considered as alternative evidence of extraordinary ability or national interest in lieu of the standard criteria. For example, they would call it akin to like a one-time national or international award or something like that. I've not yet seen any indication of the legal pathway that USCIS would use to make the gold card a reality. There was one proposal I read that suggested that it would supplant the normal EB-123 allocation, which doesn't seem to be within the current legal framework. So you may need Congress to pass a law to make that happen. And even if they did it that way, we still, unless the law changed it, we still have our protocol with all the priority dates where, let's say, if all you did was say that $2 million equals extraordinary ability, you would still have to be within our framework of priority dates and backlogs and waiting for the visa bulletin. So that remains to be seen. Now, I may have mentioned this in the last webinar or some of you on consultations. In early October, there was like a one-liner in a White House regulatory agenda proposal document that said something to the effect of our regulatory agenda includes looking at all the bases for employment-based green cards and I-140s, including EB-1A extraordinary ability and EB-2 NIW national interest waiver. Now, regulatory agenda is not illegally binding anything. It's just saying, hey guys, heads up, we might do something with this in the future. Now, normally what happens is it goes through the entire rulemaking process, notice of proposed rules making, notice of comment period, for final rule. So that's all under something called the Administrative Procedures Act. A, it hasn't happened yet. B, if it happens, we don't know if it's going to make it harder, easier, different. They could say that gold cards are extraordinary ability. They could say that anybody working in supply chain and semiconductor and AI, frontier models is national interest, right? They could do it in a whole lot of ways that could affect lots of people. And they don't have to do anything. And if they do something, there could be other challenges to it. So what I'm telling people is the only constant is change. It's very difficult to predict what would happen. It is a challenging environment to apply now. The only advantage we have right now is we kind of know what the current framework is like. If you would regret not taking this chance to file something now, and if you're okay with the risk, then by all means, we're happy to support you, knowing that we have to, surrender to the outcome. It's not within our control. We can't make, it's not within our control. We can't make any guarantees. But we won't know the future until it happens. So TBD. So that was an excellent question. I wish I could be more succinct and just tell you exactly what to do, but at least that gives you like the framework of how I think about the main types of green card options right now, November 19th, 2025. Okay. The next individual has a BALCA appeal pending since May of 25 for a denied perm. And their company has started a new perm at the prevailing wage determination stage in parallel. The current H-1B expires in May of 2027, and they need to decide to wait for the BALCA appeal or switch to the new perm. Which route do you recommend will have a better chance of approval? Oh man, I think your company attorneys are really in the best position, and I don't know if they're going to tell you the answer because they represent your employer. I don't know the statistics on BALCA sustaining the appeal, and it depends on your employer and the likelihood of layoffs and if that could jeopardize your perm. So those would be the directions to look in and the types of questions to ask. Should I be worried if I don't have any social media footprint since I am not on Facebook, Instagram, or X? No, I would enjoy your freedom. I wish I had the foresight to be like you. But all jokes aside, there is heightened scrutiny of social media profiles, but there is no requirement to have social media profiles. So please don't go creating social media profiles just for immigration. You don't have to do that. Okay, the next individual is currently on STEM OPT. What is the ideal timeline for starting the O1 process, and how early should I begin preparation to avoid any gaps in status? What are the most impactful evidence categories I should focus on as an early career designer and co-founder of a startup to strengthen my O1 case? And what should I start preparing immediately? Well, that's fabulous. So you should definitely be aware of some deadlines. You need to know your EAD expiration date, your F1 visa expiration date. I recommend starting the preparation now. But in terms of when to file, I would recommend looking at attorneys 5 months before the end of your STEM OPT so that you can file with a month to spare, and then you have the grace period. And if you use premium processing, hopefully you'd have your decision well before the end of your STEM OPT. The course I put in the chat for Alcorn Academy, that has the 15 videos, and they would all probably be really relevant to you and what you're doing. But as an early career designer and co-founder of a startup, we can actually look at both the O1A for business and the O1B for art. And so you can look at both categories. The class is primarily about O1A for business, but you can separately do research on O1B to get those details. We've done both for designers, and kind of the O1B is a little bit easier actually, but you can choose either. And I mean, when you're a founder of a startup that needs to scale rapidly and therefore you need to attract funding through traction, really your one thing should be, creating the best product possible that gets customers to adore you and refer their friends. That can feel at odds with the O1 emphasis on becoming a thought leader and an influencer. But really, you can kind of dovetail the business marketing opportunities to elevate your startup with the O1 requirements. So you can do speaking events, you can be interviewed on podcasts, you can give webinars, you can speak at conferences, you can write articles, you can use evidence of your traction for original contributions. Any funding you receive will be helpful. So there's a lot of things you can do. And I think I wrote or discussed that quite a bit in the online class and also in the book. Are there companies that help to secure EB-5 visas with just 400? Oh, gosh, I'm not going to read the whole question. I don't practice EB-5 law. I don't know the field. I don't know the players. I don't know if the opportunities are legit. I would recommend lots of caution and due diligence for any one of those that you're trying to consider. What types of awards, publications, or media coverage carry the most weight for O1 approvals in the design field, and how can I prioritize which ones to pursue next? Maybe that's the same person, but you can use stuff related to the startup success, and you can also use success related to your design career. So your field is a legal concept that the lawyer gets to decide how we're going to frame it. And it's probably going to be at the intersection between the design thing you're good at and the entrepreneurship and the product that you're building. And so if we look at that Venn diagram and the intersection, we want to show that your awards, publications, and media coverage are in that specific niche. And then that's where you should really double down and prioritize. I am on H-1B and my I-140 is approved with a 2019 priority date. I hear that you can now sponsor yourself a startup in H1. How does that work? Is it possible to transfer that back to organization if the startup fails later? Would my I-140 still be valid with the priority date? Yeah, so it's basically that something I've been doing forever that the government made official finally, but your ownership of your company is compatible with the company being your H-1B sponsor. So it's just a normal H-1B. If you're going to quit your company and go back to work for some employer, your company withdraws the H-1B and you transfer it to the new employer. It doesn't affect your I-140 at all or the priority date from it. So yeah, you can always do a change of status back to B1 or F1 or transfer to a company. You can have concurrent H-1Bs, more than one H-1B at the same time. If you're going to have a full-time, I recommend a part-time and not two full-time. But there's lots of ways to do it. The next individual says, I completed my Master of Science in Computer Science as an OPT student. I am currently working on AI automation and have even started my own company. Congratulations. In light of this, I'm interested in exploring the potential pathways to explaining an H-1B O1 or EB-1A visa. Okay, well, the great news is that on OPT, you have a lot of freedom to be self-employed, to work in your field, to do lots of different things. So now is the time to build up your O1 and EB-1 and EB-2 NIW accomplishments as much as possible while you have the OPT time runway. I would strongly suggest that your startup places you in the H-1B lottery next spring. You're welcome to reach out to us now for help with that if you'd like. And then I would also recommend just building, it's not like you need extra motivation to build your startup insanely fast. If you're a founder, that's what you're doing anyway. But the more you can, like, as I've been sharing, dovetail your startup marketing with your O1 EB1 accomplishments, the better. And then, of course, the more traction you get, if you choose to raise funding, getting funding from prestigious, notable investors or at a high valuation, all of that can help. And if it's based on traction, great. Some of my clients now want to bootstrap. They don't need anybody else's money. They don't want it. That's okay too. You don't have to accept external funding to get a visa. So it's a very individualized pathway, but you should have a lot of opportunities. The next person says, oh, I think that's a typo. That's okay. Okay, here we go. Can you provide details on the documentation proof that we should be putting together as I prepare to start an EB1A? Oh, and please ignore the previous message. Okay, yes, I ignored it. Thank you. Yeah, so definitely check out the book, check out the Alcorn Academy course when you have when you get stuck, when you're like, okay, I've done everything I can think of, is this enough? That's when you would hire us for Legal Launch, the 4-week assessment and evaluation process to determine your level of qualification for these visas. But the documentation proof, I mean, we need proof of everything. And I know that's vague, but pay slips, incorporation documents, awards, emails, websites, like printed to PDF with the timestamp and the URL, organized by category in your Google Drive with a spreadsheet mapping out each of the documents and how they relate to each criterion. Like, the more you do of that, the easier it makes our job when we're trying to write and help you draft your letters of recommendation to fill in any gaps, and then the brief. Yeah, I'm happy to share more about the O1 with the agent concept. So essentially, the O1 petition can be signed by either an employer or by an agent. And the agent represents companies or you in securing your like gig economy work when you're in the United States. So if you do an O1 with an agent, you're not limited to one job. You and your agent can put as many jobs as you want on your itinerary of services. And we craft that in such a way as to be very encompassing to limit your need to file any amendments within the 3 years. Like, I helped a guy from a top MBA program who was doing a search fund, and we got him his O1 with an agent a couple years ago. And the search fund didn't work out, but he got another job in his field of extraordinary ability. And the new company that hired him didn't have to do any visa sponsorship for him because the new job was clearly within his field of extraordinary ability and what we put on the agent's itinerary in his original O1. So it's really lovely. Like with the H-1B, you can have concurrent O1s. So some of my clients have like a full-time normal O1 for a job signed by an employer, but then they want to do like side consulting. So we get them a second concurrent part-time O1 with an agent for them to do their other stuff. Other people just want to have like a full-time O1 through an agent and they run any of their jobs through it. The only scenario that's hard, not for legal reasons, but for just like real life reasons, is that many big tech employers or like banking employers will not, they're not willing to sponsor, they're not willing to hire somebody who is on an an O1A sponsored by an agent. Their law firms will direct them that they need to be the employer for legal purposes. Okay. So let's see here. All right. Next question. After legal launch, if I'm qualified for either an EB-1A or an EB-2 NIW, what would be the next steps? What would be the more support further? You could hire us to do the case. We have a very detailed process that I've created and evolved over the years that includes a welcome call, a case strategy meeting, detailed support on your letters of recommendation, either editing them or also drafting them if you use our white glove service options, drafting your forms, your legal brief, your exhibit list, all of your exhibits, doing a comprehensive review, submitting everything to the government, tracking everything, answering your questions along the way. So those are just a sampling of some of the services we offer as part of our full visa preparation packages. Okay. Got about 10 more minutes. If we hire someone on STEM OPT, what are some key things we should be aware of to be able to support the H-1B visa sponsorship? How is the current process of a change of status with all the latest changes and policies? Okay, so for STEM OPT, if they've already gotten STEM OPT approved, you need to be enrolled in E-Verify. You need to create a comprehensive training plan for them that they will have on file with their school in their SEVIS record. And you'll have to employ them for at least 21 hours a week at minimum wage in the location where they're working in a job that's compatible with their field of study. You can put them in the H-1B lottery. Would highly recommend it. They might actually have a very high chance of getting selected next year because I think a lot of employers are opting out of the H-1B lottery because they don't want to deal with the current situation. But if they're physically in the US on STEM OPT, maintaining valid F1 status, and their H-1B is selected and you choose to file for them as a change of status, then they would not be subject to the $100,000 fee. So I recommend to a lot of people to do that. For immigrant founders operating a SaaS business serving global customers, if the entity is incorporated in the US as a Delaware C Corp, what would be the most compelling visa pathways for entry and long-term stay in the US? Depends on what country the person's from, but let's assume India for now. If it's a brand new company, then I would suggest an O1. If the founder's in the US, I would suggest trying the H-1B lottery. And if the company already has employees and a subsidiary or something in another country, then I would suggest looking at the L1 visa. And if the person's not pursuing a startup that would be venture-backed, and they're not from India, China, Brazil, Russia, the Philippines, but if they're from a country with a specific treaty, they might also be eligible for an E2 visa. So there's a variety of options to choose from. I obtained my bachelor's of engineering in the US and worked all 3 OPT years. I'm working based on CPT because I'm pursuing a master's degree that ends in July of 26. Can I found a startup at this point? You'd have to get your school's permission to have your startup be your CPT employer, or we would need to put you in the H-1B lottery and see if you get selected through the startup, and then you'd have to form the startup but not work there. Or you could do a CAP exempt concurrent H-1B situation where we use like a fellowship to get you a part-time CAP exempt H-1B for maybe 5 hours a week, and you teach US college students and they get you an H-1B without the lottery, and then we tack on a second concurrent H-1B for full-time work at your startup. Or you could get an O1. Those are the main pathways. My wife has a valid H-4 EAD, but she hasn't worked on the EAD due to family issues. During the next extension, will she have any issues? Nope. There's no requirement to work on that status. Should be totally fine. As per the current scenario, does the academic H-1B, for example, H-1B applications from the National Interests of Health or National Institutes of Health also required to pay the $100,000 fee, not for people in the US. So if the H-1B beneficiary candidate, the worker, is physically in the US on another status like F1, H4, O3, something else. And if the new employer is filing for them as a change of status, it's fine. They stay in the country, they don't leave, there's no $100,000 fee. I'm on an H-1B and I have an I-140 approved. My wife is an F1 OPT, but reaching the final attempt. What should I do to get an H4 EAD? I assume this means for your wife. You should talk to your employer to look for any opportunities to extend or amend your H-1B. You can pay for premium processing if they won't, and then you would include her H-4 change of status and H-4 EAD work permit application in the same bundle. Okay. If the automatic extension has ended and you've applied and you did not hear from USCIS until after the expiration date, yes, it will likely affect your status, because if you're in a category that no longer has an automatic extension and you filed and you're waiting, but your current time period has ended, then you would need to wait for the approval to resume working again. For the O1 with agent scenario, does the applicant need to arrange an offer letter from any potential employer? Yeah, we need proof that you're going to be working, doing jobs, but it can be part-time employment, contract employment. It can be very flexible. So we would evaluate what you need based on what you want to do. The next question is, my academic H-1B extension filed in August was recently approved, and I'm going home to get a visa stamp. My contract and visa petition uses a clear job title, but in academia, it's common to have a bunch of acting roles: director of a program, lecturer, member of a group, which are listed online. These responsibilities, she leads the X program and teaches, are described in the job description attached to my visa petition, but the exact acting roles are not listed. They say, should I worry? I would say that if you just want to be like, there's no rule on this, and it's very common what you're saying, but if you, maybe it would give you more peace of mind if you draft up a letter for your employer to sign that you can take with you to your visa stamping that says, like, we love Professor so-and-so in their H-1B role of blah, blah, blah. And then you like copy and paste from the I-129 what you're specifically allowed to do. Like, this person's so great. And like, here's all the examples of the ways that they are actively fulfilling this role through their external engagements. And then you could like list all the things you're worried about. And it's like, if you have any other questions, please let us know. This is a great person. We can't wait for them to attend or, return to us in the US and continue on their important work. Like, you could have a letter like that with you as a backup in case you need to pull it out and show it to somebody. I wouldn't start with that, but it might give you more peace of mind for traveling. Will the first screening happen when they complete the DS-160 and then schedule the consular appointment, or after the interview at the consulate, or does screening already take place last week when my visa extension was approved in the US after my biometrics appointment? Are you submitted? Screenings happen at all these times. They happen while the H-1B petition's getting approved. They happen from the time you complete the DS-160 to the time of your interview, and they can happen after the interview until you get your visa, and they could even happen after you get your visa. So it's all of the above, but the main thing would be being able to explain anything at your appointment. Is the EB-5 different from the gold card? What are the risks? Yeah, I think I explained that after the question was answered, but the gold card doesn't formally exist yet. The EB-5 has existed for decades. The gold card might be $1 to $2 million. You are not going to get the money back, according to what has been shared so far. I entered in the US in 2018 on L1. My employer filed my EB-2 perm and switched me to H-1B. However, I've not left the US since 2018. I'm working as a manager. Can I still qualify for the EB-1C given it's been 8 years? I believe your employer should try it for you. It's not guaranteed to work, but usually in your situation, it gets approved, but it's kind of a rare situation. But they normally are supposed to look at the time. Did you work for a year for the company abroad in the 3 years before you came into the US on your L1? So I would try it. For the new EB1A regulations proposed to come out in January, is it fair to assume that it will still go through the 60-day notice period process so that we will likely have until Q1 of 26 to file under the current rules? Yeah, look, I know people apparently have been seeing more about this. Am I sharing? No, I'm not sharing my screen. Okay. I have no idea. If you've been reading stuff about this from other lawyers that you can share with me, like on LinkedIn or my email, sophie@alcorn.law, I'd love to read anything else that anybody's saying about this. I don't know if they're coming out in January. There's supposed to be a normal 60-day notice period, but there's probably exceptions, like if there's some sort of urgent situation where, they might be able to get an exception. So I have no idea. Okay, a few more minutes. Lightning round. I've heard about certain folks filing an O1 with an itinerary. Could you please share a high level? I think I covered that. Feel free to reach out if you need more details. Given the recent speed of layoffs, would you suggest that having a concurrent H-1B as a backup? Yeah, I've suggested that for years. I read about that in TechCrunch like 3 years ago. Is it easiest done through a startup or a part-time role? Whatever job you want to do through your connections that makes business sense, like you can convince people to help you where needed, like do that one. It doesn't matter to the government if it's a startup or a part-time role. I'm on an H-1B visa. Can I self-sponsor a startup as the concurrent H-1B visa and not resign from my original job? Yes, but then you have other non-immigration considerations to confirm before you proceed. You need to make sure that you're not jeopardizing your employment in your current job, unless you don't care about losing it. And you need to ensure that the intellectual property of your startup is clearly defined in the property of your startup and that your current employer doesn't have access to it. Okay, H-4 EAD to H-1B, is that still possible? Yes. Would the 100,000 fee rule apply in this case? It does not. You can do it. If I transfer my cap exempt H-1B to a non-cap exempt H-1B with a company, will I be subject to the $100,000 fee? No, you will not be, as long as you do it in the United States as a change of status. I have an approved I-140, but I'm considering switching to a new company. If the new company's perm gets rejected, would it reset the I-140 priority date? No, that's your priority date for life. Is there any increase in new perm denials seen recently? We've seen more RFIs than audits, but I have not heard or seen anything personally regarding any change in perm adjudication overall trends. If you already have an H-1B, what are the eligibility criteria to sponsor yourself an H-1B visa? What would it take? Commitment and money. You literally need the company incorporated, ready to do business, registered, bank account, funding available, job description, business need. So that's what we review in our consulting program. That's $3,000 in typically 3 weeks. And then how to redeem the legal launch perk offered to the webinar participants. Just complete the questionnaire link or email us at hello@alcorn.law and say somewhere in there, I was on Sophie's webinar on November 19th, and she said that legal launch would be free for me. Please, can I sign up for legal launch? And we'll get you started. Thank you. Okay, and then I said I wouldn't look at the chat window, but in trying to be complete. Okay, we covered the letter recommendation one. If somebody's going to travel on OPT, you definitely double check when your F1 visa is expiring. And I would probably encourage you to add premium processing to your pending EAD to get the decision before and the card before you decide to leave, so that you have the card on your trip so you can return most easily. And the EB3 visa, if you're not from India or China, it might take 4 to 5 years, maybe. maybe from start to finish. And then a change of status, transferring the H-1B from an academic role to a company H-1B. Do I have to go through the lottery? Yes, you normally do. Okay. Oh my God, only 2 minutes late. Amazing. Well, thanks everybody. Thank you. Gosh, like most of you stayed with me to the end. I really appreciate it. I hope this was helpful. I wish you all the best. Thank you so much and have an amazing rest of your day. Bye, everybody. Thank